Now, Honorable Senators, this morning, at the commencement of the hearing for the removal from office by impeachment of His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, Legal Counsel for the Deputy President, Mr. Ndegonjiru, Learned Counsel, raised a preliminary objection on the legal representation for the National Assembly. Learned Counsel opposed the appearance of Honorable James Orengo, Senior Counsel, who is the serving governor of Siaya County and therefore a state officer. Learned Counsel submitted that the Honorable James Orengo is a full-time serving state officer, as per Article 260 of the Constitution, as read together with Section 26, subsection 2 of the Leadership and Integrity Act, which bars a full-time state officer from engaging in any other gainful employment. Counsel further submitted that it would be prejudicial to the Deputy President if the Senate allowed Honorable James Orengo to represent the National Assembly in these proceedings. Counsel drew the attention of the Senate to the precedent set in the matter of the proposed impeachment of the Deputy Governor of Kisii County, Honorable Richard Munda, in which a decision was taken to bar Honorable Sylvanus Osoro, Majority Whip of the National Assembly and Member of Assembly for South Mugirango in Kisii County, from appearing as counsel for the Kisii County Assembly. In his submission, Counsel cited Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, as well as the decision of the High Court in Office of the Director of Public Prosecutions versus Orengo, Manduka and two others, interested parties, Constitutional Petition 204 of 2019-2021, KHEC 456 KLR 27 April of 2021, where Honorable Justice Ogola found and ruled that the continued representation of the first interested party, Mr. Manduku, by the respondent, Honorable James Orengo, as then was, or any other state officer is against the spirit of Chapter 6 of the Constitution for failing to conform to the mandatory provisions of the Leadership and Integrity Act. The judge ruled that in that case, there was an inescapable conclusion of conflict of interests in Senator Orengo representing the petitioner, highlighted by the fact that the interested party, Mr. Manduku, the Managing Director of KPA, may at one time be summoned to appear before a committee of the Senate to answer to some of the matters that the petitioner was being investigated on. In response, Mr. Eric Gumbo, Learned Counsel for the National Assembly, submitted that Article 77 of the Constitution is the primary law that restricts activities of state officers, and it specifically prohibits a state officer from engaging in any other gainful employment. Counsel further relied on Section 26 of the Leadership and Integrity Act, which he submitted has defined gainful employment, and in this matter no evidence had been laid that the Honorable James Orengo was participating in gainful employment. Counsel referred the Senate to the decision of the High Court in Busia Election Petition number 3 of 2013, where the court interpreted Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act 2012. Counsel also cited the decision of the court in the Mwilu case, which defined conflict as where one is confronted by two different interests, where one is competing with the other. Learned Counsel for the National Assembly submitted further that no prejudice has been demonstrated that would arise or be occasioned to the Deputy President by the participation of Honorable James Orengo in these proceedings. Learned Counsel for the National Assembly sought to distinguish the decision by Honorable Justice Ogola in the Office of the Director of Public Prosecution versus Orengo on the basis that this case turned on the fact that Honorable James Orengo was at that time a sitting senator before whom the matters in respect of which his client was charged could potentially come for adjudication in the Senate, and that no possibility exists into the current matter with Honorable James Orengo as the Governor of Siaya County. In his rejoinder, Mr. Njiru, Learned Counsel, submitted that Honorable Orengo is the serving Governor of Siaya County and therefore a full-time state officer, and by that fact alone is a violation of Article 77 of the Constitution. Further, Mr. Njiru submitted that prejudice is not one of the applicable tests under Article 77 and Section 26 of the Leadership and Integrity Act, but that The only applicable test is whether or not Honorable Orengo is engaged in gainful employment. He argued that the National Assembly had not proved that Senator Orengo was providing pro bono services in this matter. Honorable Senators, Article 77(1) of the Constitution provides that a full-time state officer shall not participate in any other gainful employment. Further, Section 26 of the Leadership and Integrity Act provides that a full-time state officer shall not participate in any other gainful employment, while Section 26(2) defines gainful employment as work that a person can pursue and perform for money or other form of compensation or remuneration which is inherently incompatible with the responsibility of the state office, or which results in the impairment of the judgment of the state officer in the execution of the function of the state office, or results in conflict of interest in terms of Section 16. Having considered the matter, it is important to state that a state officer must inspire confidence. However, it is tried law that he who asserts must prove. In this regard, I wish to observe that the learned counsel for the Deputy President did not adduce evidence to prove indeed and demonstrate that the allegation of gainful employment. In fact, it is somewhat surprising that counsel attempted to shift the onus of proving gainful employment to the National Assembly. That argument is untenable. As to the ruling of the Senate that barred Honorable Osoro from appearing for the County Assembly of Kisii in the impeachment proceeding of the Deputy Governor of Kisii County Government, it is clear that what was objectionable was that Honorable Osoro was not only a member of Parliament for a constituency in the same county whose Deputy Governor's impeachment was an issue, but also a high-ranking member of the leadership of the National Assembly, and by extension of the same Parliament before which the impeachment was being undertaken. It was ruled that in these circumstances, it was clear that in the minds of the public, the fine distinctions of the bicameral Parliament would be lost, and their confidence in the impeachment process would entirely be undermined. In the same breath, as rightfully contended by counsel for the Deputy President, it is true that in both Article 77 of the Constitution and Section 26 of the Leadership and Integrity Act, no test of prejudice is expressly provided for. It therefore follows that both the contention of the counsel for the Deputy President that his side will be prejudiced by the appearance of Senior Counsel James Orengo and the rebuttal by the National Assembly that no prejudice will be occasions are moot. Honorable Senators, ladies and gentlemen, having analyzed the preliminary objection raised and for the reason I have given, the preliminary objection raised on the appearance for the National Assembly by Senior Counsel James Orengo is hereby dismissed. We will now hear the response on the second objection raised by the counsel for the Deputy President. Counsel, you have 5 minutes to do that.
Thank you very much, Mr. Speaker, sir. I'll endeavor to respond to the preliminary objection within the time allowed to us. Mr. Speaker, sir, the objection was premised on Rule 20 governing the proceedings that are currently before this House. The rule reads that in presenting its evidence, the Assembly shall not introduce any new evidence that was not a part of the allegations against the President by the National Assembly as forwarded by the Speaker to the National Assembly to the Speaker of the Senate. Mr. Speaker, sir, the context of this rule is important. A true reading of this rule would indicate or would mean that every material that was available before the National Assembly while deliberating the motion that was before it is what is contemplated to have been sent to the Speaker of the Senate. The question, therefore, that we'll be asking ourselves this afternoon is whether there is any new evidence that has been adduced by the National Assembly. Our answer to that, Mr. Speaker, sir, is an emphatic no. And why do we say no? We say no for the first reason that the reference to the letter forwarding the material that came from the National Assembly contained, amongst other items, paragraph 21, which spoke to a report of a public participation that was conducted by the National Assembly. Mr. Speaker, sir, that report was tabled on the floor of the House, was adopted by the House. Deliberations in relation to that report were made. Not a single objection arose. It certainly follows, therefore, that that material from public participation became a necessary part of the material that was considered before the National Assembly. To give it context, Mr. Speaker, sir, in addition to the material that was presented by the mover of the motion to the National Assembly, the honorable members of the National Assembly had their deliberations, which also captured in the Hansard. In that Hansard, material was introduced by way of questions, by way of contribution from the floor of the House. That material too forms part of the evidence of the proceedings before the National Assembly. It therefore is our submission that just in the same manner in which the Hansard from the National Assembly forms part of the report that was presented before you, the report on the public participation too is an important component of that report. There must have been a reason why that public participation was conducted. In our humble submission, Mr. Speaker, sir, the appropriate test that one would want to apply on whether or not to apply, to allow that material to be before this honorable House is the all celebrated test of relevance. Mr. Speaker, sir, it should not be lost that sitting as this House is sitting this afternoon, it is a quasi-judicial proceeding. It is a proceeding that is also inquisitorial. And so therefore, what is important is that the material that is presented by way of public participation or by any other way is relevant to help the House determine the truth or otherwise of the issues that have been raised for the consideration of this House. How then, Mr. Speaker, sir, do we get to answer that question? Mr. Speaker, sir, I've had a look at the specific document that my learned friend, Mr. Njiru, objected to. And Mr. Speaker, sir, it is an affidavit by one Mr. Peterson Njomo Mushira. Mr. Speaker, sir, Mr. Njomo Mushira says that he followed the proceedings before the National Assembly. He says in particular at his paragraph 4 that he has also had occasion to look at the response filed by His Excellency, the Deputy President of the Republic of Kenya, at part 1.1 of his response. And he says that he has personal knowledge of the items that were contained or that would give clarity to part of the assertions in response by His Excellency, the Deputy President. Mr. Speaker, sir, for context, that part 1.1 is contained in volume 6 of one of the volumes that were presented before you. It is the volume speaking to the response by His Excellency, the Deputy President. At part 1.1, Mr. Speaker, sir, it speaks about a hotel called the Olive Garden Hotel. In particular, at part 1.1.4, His Excellency, the Deputy President, says, in accordance with his instructions, the hotel was sold by executors to a third party. Mr. Peterson Njomo Mushira, on the other hand, says, I have information that could
counsel
help.
For the National Assembly, 1 minute.
Thank you very much, Mr. Speaker. Mr. Peterson Njomo, Mr. Speaker, then says that he has information which indicates that number one is a shareholder to the company which bought that hotel, and that according to him, Mr. Speaker, sir, he got into a secret transaction with His Excellency, the Deputy President, to buy that hotel. Mr. Speaker, sir, it is our submission that that is material that is relevant for purposes of consideration of the matter that is before this House. Mr. Speaker, sir, I urge that that objection be dismissed. I'm most obliged.
Thank you. Honorable Senators, ladies and gentlemen, we need not take a break to allow me prepare my ruling. Just give me a minute. I'll put my thoughts together so that we make progress.
Mr. Speaker, sir, with your kind permission, I was just seeking your guidance whether I need to do a rejoinder because I'm the one who had moved the assembly in respect to the...
Very well. You may go ahead as I put my thoughts together.
Thank you very kindly, Mr. Speaker, sir. In response to what my learned friend has raised, the application or the objection had nothing to do with the public participation as cited. We simply raised an objection that goes to the roots of the ability to enjoy proceedings that will appear fair to all parties. My objection was premised on the non-derogable right to a fair hearing. Counsel has addressed you that the deponent of that affidavit, one Jomo, was responding to the Deputy President's response. There's nothing that can be far from the truth, and this is a witness who is being brought to panel beat or to attempt to panel beat the case for the National Assembly. The question and the test, Mr. Speaker, sir, is, shall we suffer prejudice? Shall our rights be deemed to have been held? And that is the non-derogable right to a fair hearing. This is not a witness who was before the National Assembly. Where is the source of this information in the document that was submitted to this House by the Speaker of the National Assembly? Where does it sit? Who sits to suffer prejudice if the same is admitted? Is it a state organ or an individual in the name of the Deputy President of the Republic of Kenya? We urge you to uphold our ruling and justice be seen to be done, even to the people following these proceedings. I am most obliged.
Now, Honorable Senators, the second preliminary objection raised by the Counsel for the Deputy President was that the following documents which were submitted by the National Assembly on Monday the 14th of October 2024 were not part of the bundle of documents of the National Assembly that was served on the Deputy President on Wednesday the 9th of October 2024. These are an affidavit sworn by Mr. Peterson Jomo Mushira, and B, the document of the National Assembly marked as Volume 8A, responses from various government agencies. Counsel for the Deputy President stated that these documents prejudiced the Deputy President's case and amounted to a trial by ambush by the National Assembly. Counsel urged the Senate to bar the introduction of these two documents as they constitute new evidence in terms of Rule 20 of Part 1 of the second schedule to the Senate Standing Orders. Counsel for the National Assembly opposed the preliminary objection raised by the Counsel for the Deputy President. Honorable Senators, ladies and gentlemen, Rule 20 of Part 1 of the second schedule to the Senate Standing Orders provides, and I quote, "In presenting its evidence, the Assembly shall not introduce any new evidence that was not part of the allegations against the President by the National Assembly, as forwarded by the Speaker of the National Assembly to the Speaker of the Senate." As I indicated in my earlier communication, by a letter dated 8th of October 2024, I received a bundle of documents and records of proceedings in the National Assembly in this matter. Thereafter, on the 9th of October 2024, pursuant to Rule 6 and 7 of Part 1 of the second schedule to the Senate Standing Orders, the Office of the Clerk of the Senate sent invitations to appear to both parties. The parties were required, amongst other things, to specify any other evidence to be relied on this matter. I will repeat that. The parties were required, amongst other things, to specify any other evidence to be relied on in this matter. In response to this invitation, on Monday, 14th of October 2024, the National Assembly filed further documentation. Having analyzed the documentation submitted against the grounds for the proposed impeachment, I find that the documents objected to constitute evidence in support of the allegations already made in the impeachment motion as received from the National Assembly. It is noteworthy that the parties were instructed when sending responses to indicate any other evidence to be relied on. Accordingly, the documents being referred to do not constitute new evidence, but form evidence in support of an allegation which was already made. That is why Rules 6 and 7 of the Rules of Procedure permit the Senate to receive witness statements, list of witnesses to be invited by and any other evidence to buttress an allegation already made. What is not allowed is to introduce new allegations or to introduce any evidence that is extraneous to the allegations made in an impeachment motion. In the event, it is my considered view that the affidavit and document marked as Volume 8A being referred to fall within the permissible documents of our Rules of Procedure. I therefore rule that the objection is hereby dismissed.